The Court of Appeals, First Appellate District of Ohio, with the Honorable Jennifer Kinsley presiding, is now in session.
Good morning, everyone. Welcome to the First District Court of Appeals. Thank you very much for your flexibility in switching to remote arguments this morning. We hope everyone is staying safe and warm during this weather event. We have 4 cases on our docket this morning. I will begin by just running through the list of cases for the benefit of people watching remotely. The first case is Asbury Woods Senior Apartments versus Gloria Render, case number C250297 and 298. At the request of appellant Gloria Render, that case has been submitted on the briefs and we will not be hearing oral argument this morning. The second case we will hear is C250144, 3115 Durrell Apartments versus Clyde Austin. And I see that Mr. Austin and Mr. Donnett are present on Zoom this morning, and we'll begin your argument in just a minute. The third case is Peonian Enterprises LLC versus Fitworks Holding LLC, case number C250058. And then the third case that we'll hear argument for is Karen Johnson versus Dr. Durrani, C250064. And I understand that the attorneys on both of those last 2 cases have checked in and are present, and we'll be hearing from them on Zoom later on this morning. Mr. Austin, you'll begin. You're the appellant in your case, and you'll begin by arguing your case first. You'll have 15 total minutes. We'll hear from you first and last. You get to divide the 15 minutes up however you would like, reserving as many minutes as you would like for your rebuttal time, the second part of your argument. How would you like to split up your 15 minutes? How much of it would you like to save for your rebuttal?
Your Honor, I would like to save 5 minutes for rebuttal.
All right, and I'll give you a warning when you have about 1 minute left in your initial 10 minutes. That'll be a verbal warning from me so that you can properly prepare your argument, and you may proceed whenever you're ready.
Okay, Your Honors, if it may please the court, my name is Clyde Austin. I'm the appellant in this matter. And this case before us today involves a great matter of public policy. What I've experienced in this matter is a total egregious fraud upon the courts committed by David Donnett, the appellee's attorney. Mr. Donnett filed a 3-day notice that is void ab initio on the grounds that it did not meet the strict standards, filing standards with the 3-day notice. Mr. Donnett interjected a sum of $1,413 in his 3-day notice after stipulation that the rent was $1 from HUD. And that was verified through a document that was submitted in the Journal of Record in the municipal court as defendant explained plaintiff exhibit P, page 1 through 3. After the initial stipulation that the Austin's rent was $1, Mr. David did not then relitigated the case, which was prevented by the doctrine of res judicata. Refiling the case, altering case numbers. The original case was submitted to the Common Pleas Court on the case number A2300960. Unfortunately and consequently, the dockets was altered to state that the cases was consolidated by Judge William Mallory, and in fact, the case was consolidated by Melissa West in the Hamilton County Municipal Court. Upon that consolidation, there was a hearing held where Mr. Donnett stipulated and admitted that the rent was $1, and it was verified by the HUD document. Your Honor, I also submitted to the courts a rental registry of the appellee's own rental record of the tenant Austin from 2022 to 2023, which states in total that Austin's rent was $1 from the year 2022 to the year 2023. And that document also stated that Mr. Austin's rent from February 1st, 2022 till that would be February 2023, rent $1. I'm new at this, but I will say this one thing, that what I've experienced, I want to prevent other women with children on low income housing, men seeking education and housing and better employment from this systemic scheme of fraud upon the courts. This act has caused great harm, not only to myself, but people that's on disabilities It's causing harm to low-income families. It's causing harm egregiously to the judicial system itself. Again, I've already submitted exhibits of the tenant statement from the appellees itself, and it clearly identifies that Austin was never in default. The Ford ab initio comes in, the courts never had jurisdiction to hear the case due to failure to meet the standard requirements. And again, Mr. Donette, after the case being transferred to the Common Pleas Court, called witness Christine Valut to testify under oath that I was in debt of $1,413 after she and Mr. Donette had internal communications agreeing that they did withdraw the case due to the fact that it was discovered that my rent was current. Again, the tenant statement verifies I was current on my rent. That was submitted, and that tenant statement is from February 1st, 22 to January 9th, 2023, marked as the exhibit plaintiff defendant number 1. The rental tenant statement verifies that I was current.
Mr. Austin, I have a question for you, and thank you very much for sharing your experience with us. Are you complaining that you were evicted from the apartment, or that you were made to pay money to the landlord for back rent, or both? Are both things upsetting to you? I just want to make sure that I understand.
Yes, ma'am. I'm sorry, Your Honor. I resided in the apartment for 5 years. HUD paid my rent from the time this eviction started up until the time I was illegally evicted and thrown out of my apartment. I was unlawfully evicted. The appellee has received funds, HAP payments from the HUD from 2022 up until the day I was evicted, which was March the 4th, 2025. They received those funds, although they were not entitled to those funds. According to HUD's contract, once a place of residence is in abatement, they were not entitled to any funds whatsoever. But from my understanding, they have received all funds from the year 2022 throughout the eviction process up until the day I was illegally thrown out of my house and forced to enter into a homeless shelter. And as I said again, Your Honor, my whole hope today is that we need to stop this systemic scheme that's been perpetrated on low-income tenants and against the Public Housing Commission. The public is at risk if we can allow skilled attorneys to manipulate the judicial system through altering of documents, manipulating records, and then again, grossly committing fraud upon the courts. Again, I will repeat this one more time, that I was unlawfully threw out of my apartment through a retaliatory eviction. I paid all of my portions of my rent from the day I was living in the apartment in 2020 up until 2025. I never received a statement, a warning, a termination from HUD Housing from the time that I stayed there. There was no warning that, Mr. Austin, you are in violation of your tenant contract, in which I never was. The appellee, on the other hand, was in violation of their tenant contract by being in abatement from 2022 to 2024. The apartment was tremendously infected with bed bugs. They had major problems, and I've submitted the documents that I've had to the courts. The thing that I'm hoping for today, Your Honor, is that we get to the point and understand skilled attorneys cannot deprive people of their housing. They can manipulate the system.
Mr. Austin?
Yes, Your Honor.
So you had counterclaims. What happened to your counterclaims in this case?
Well, Your Honor, Judge William Mallory, I filed a motion to amend my counterclaims. William Mallory granted those counterclaims and also granted my motion to transfer it to the Common Pleas jurisdiction. Once those counterclaims once they were transferred, Your Honor, the magistrate Allison Hathaway dismissed all of my counterclaims without a hearing. I filed a motion for contempt of court. I filed a motion for default judgment. They were dismissed without a hearing.
So they're all, so your counterclaims you're saying were dismissed by the court?
Yes, they were dismissed by Magistrate Allison Hathaway without a hearing on the merits. although they were granted by a lower court. And if I'm correct, Your Honor, the law of the case doctrine states that once the case is settled in municipal court, in which it was, Mr. Donat signed and stipulated the fact that I was current on my rent, withdrew that force of entry detainer and money. They both were consolidated, the holdover of the claim and the force of entry detainer and money. So once Mr. Donat stipulated in writing, he also signed the superintendent form 4, which stated that this case was originally filed and transferred. There's been a lot of altering of
Mr. Austin, I have a question for you. Did Judge Hathaway, did she just tell you, like in court one day, that she was going to be dismissing your counterclaims? Or did you get something in writing from the court, an entry, a written order saying that your counterclaims were dismissed?
Your Honor, this was during trial. She dismissed my claims the date of the trial.
So she told you in court, she said to you in court, I'm going to dismiss these during the trial?
Yes, ma'am, she did. Also, my depositive motion, she simply said, I'm not going to entertain these 12B motions, although I requested a hearing on those motions. And I believe I had a right to access to the courts.
Okay, Mr. Austin, do you ever remember getting a piece of paper from the court that said that those counterclaims were dismissed?
No, ma'am, I did not. I never received a document from the court stating that those counterclaims was dismissed. I was appalled when it did happen the day of trial.
All right.
But I can't.
We've looked through the record and we can't find a court order. While the judge might have told you that in trial, we can't find a court order saying that those counterclaims were dismissed. So it looks to us like perhaps they haven't fully been dismissed. Would you agree with that?
Your Honor, what I can say is that during the day of trial, the judge simply stated that I'm going to dismiss your counterclaims, other than the retaliatory eviction, which was consolidated with Mr. David Donat's so-called motions or his evidence. The judge did allow me to submit photographs of the infestation of the apartment, which was joined with Mr. Donat's evidence.
You have about 1 minute left. You have about 1 minute left.
Okay, Your Honor, again, my hope today is to prevent systemic schemes such as this, depriving low-income tenants, mothers with children and infants, from being deprived of their constitutional right, their human rights, and their tenant rights in Ohio from this systemic scheme and deprivation of access to the trial courts.
Thank you very much, Mr. Austin. You'll reserve your 5 minutes and we'll be back to you in just a moment after we hear from Mr. Donat. And if you could please mute your microphone, if that's an option on your end, that would help us in hearing opposing counsel. Mr.
Yes, ma'am,
Donat,
I'll do that now, Your Honor.
Thank you very much. Mr. Donat.
Thank you, Your Honors.
Thank you. You may begin when you're ready, Mr. Donat.
If it please the court, many of the facts that Mr. Austin is raised are simply inaccurate. There were 2 cases consolidated. Mr. Austin has seemed to concentrate on the money claim. What occurred is nothing was dismissed in municipal court other than this. At one point, there was an issue that there was a bond set of $50 a month. Mr. Austin continued to pay $1 into court. There was a hearing when I filed a motion for contempt. That motion for contempt was for failure to post the proper bond. Mr. Austin showed up with information that the Section 8 had somehow reduced his rent to $1. We withdrew the motion. That's the only thing that occurred in municipal court. The full case of the eviction and the full case of the money claim, second cause, remained. In addition, as Mr. Austin mentioned, his apartment was thoroughly infested with bed bugs. Mr. Austin had been on the property for several years. As a result, once the first year is completed on Section 8, he becomes a month-to-month tenant. For the health, safety, and welfare of the people living around him, because the bed bugs were spreading, we filed a second notice against him, filed a second complaint, which was terminating his month-to-month tenancy. Those two cases were consolidated. His counterclaims took us to common pleas court. Now, one thing I would point out is that when Mr. Austin moved into this property, he was under eviction at another property. His counterclaims were word for word the counterclaims that he had filed against that previous landlord. So either every landlord in the United States is a slum landlord, or he just duplicated what he had done.
Is that in the record?
Huh?
Is that in this record?
We raised it in argument. Again, there's
Is
no.
it relevant though to this case?
Well, only from the fact that I think it indicated to Judge Hathaway that there was a good chance that there was no merit to his counterclaims. He also, I would point out, was given several opportunities by Judge Hathaway to submit evidence to substantiate his counterclaims.
I think one of the problems we're having here, as Judge Kinsley said, is that there's nothing in the record indicating that those counterclaims were dismissed. Apparently this happened orally at the beginning of the trial. Are you aware of any order that dismisses these counterclaims?
I'm not aware of that. No, I do, but not all the counterclaims were dismissed. The only counterclaim that was not dismissed, was his retaliation claim. And he had the opportunity to present that to the court.
Right. So that counterclaim was tried through to verdict, but there's a number of other counterclaims that have not been, at least in a written entry, have not been disposed of by the court. Would you agree with that?
I cannot disagree. Judge Hathaway gave him several opportunities after the trial started to present evidence.
How would that? I mean, the record doesn't exactly reflect that, because only the retaliation claim was tried to the jury. So how would he have presented evidence on counterclaims that weren't being tried?
Well, it was only after we closed our case that she dismissed his counterclaims, because there was no evidence presented to substantiate any of them.
So are you saying that was, I mean, was that a JNOV, or what civil mechanism was used to dismiss these claims? Directed verdict? What?
Well, there's nothing in writing of a judgment with, JOV or any of that stuff. She basically indicated that over the course of the trial, the issues he had raised were not, as affirmative defenses, were not raised, were not properly raised, or were not substantiated. The result of that was that the judge dismissed those, let him proceed. This case tried to a jury for 5 days. There's no transcript, I think, which would establish what her thinking was behind this. And the jury found, one, that the money claim was legitimate, and two, that we were entitled to have the eviction. In fact, we ended up having to set him out because he did not vacate in the time given.
Well, the first 3 assignments of error that he has raised go to his counterclaims. And we can't ascertain from the record in front of us, given the absence of a written entry, what exactly happened with these counterclaims.
The judge went through each counterclaim with him at the close of our case when his case was to proceed. Again, there's no transcript, so
And there's also no entry, and judges speak through, the courts speak through the entries. So would you agree that these claims survive?
no, because I think the final entry says that the counterclaims judgment was for the plaintiff on the counterclaims.
It does not say that.
Okay. I thought it did, but again, the jury heard the evidence. What Judge Hathaway did, Judge Hathaway did.
So what
But-
would be the remedy if the counterclaims have not been disposed of in writing by the trial court? What's the remedy for that?
I think the trial court can correct the record and dismiss in writing the counterclaims.
And then would Mr. Austin be able to appeal that order?
Because I would assume so, it would be a final appealable order, and then we'd be right back here without a transcript.
Did you file a 12B6 motion to dismiss the counterclaims, or were they just answered?
We just answered them. No, there was no motions for summary judgment. My personal opinion was until we got to the actual trial, there were questions of fact on his counterclaims that needed to be addressed. For instance, he raised health issues. We put on an exterminator who indicated that all the bed bug issues stem from his apartment, even though the exterminator had on several occasions cleared the whole building. They kept reoccurring, and the center of the bed bugs was his apartment, which again is why we gave him the 30-day notice. And he seems to center on this money claim, but we prevailed on both of our claims that were consolidated. The jury found that we were entitled to terminate the notice, his tenancy, based on a termination of a month-to-month tenancy. And the jury found that there was arrearages that accumulated over the years that allowed us, and we established this with ledgers, to give us a money judgment. I mean, I'm open to questions, but it was hard to address his brief without a transcript. And I think the court itself cited the case that says without the transcript, you have to assume that the judge ruled correctly. And we would stand by that case and the judge's decisions. I have nothing further.
Thank you. We appreciate your argument. Mr. Austin, you have 5 minutes remaining of your time.
Yes, ma'am. Thank you, Your Honors. Mr. Donat states that the judge dismissed my counterclaims. I raised an issue of the fact that Mr. Donat filed a motion in limine 1 day before trial, and it was granted. That's how all my counterclaims got disposed of. And he mentions a rental ledger.
Wait, what was the
rental
motion
ledger that he
in
submitted
limine? What was the motion in limine that he filed? What did it
to
say?
dismiss all my counterclaims? Ma'am, I'm sorry.
Oh, it was a motion in limine to dismiss your counterclaims? Okay.
Yes, ma'am. Yes, Your Honor. And it was granted by the judge, although it was filed outside of the time procedures. He mentions a rental ledger. His rental ledger is contrary to the original rental ledger that is already in the Journal of Record. The rental ledgers that he manufactured and submitted to the courts were a false tenant ledger. It doesn't include the tenant registry from their own files, which is the tenant statement from February 1st of 2022, January 9th, 2023. He also mentions that that the eviction was wrong. The eviction was not wrong. What occurred was this: they retaliated against Austin for filing to the HUD housing quality standards. They were constantly in abatement for rent. Me filing to exercise my protective rights, which led to this retaliatory eviction. Mr. Donnet has been receiving HAP payments from the time I was in that apartment up until the time they illegally threw me out of my home and led me into a homeless shelter. The HUD documents from August the 31st that I presented to the courts verifies that I was calling on my rent before the filing of the eviction, during the filing of the eviction, and even after. The bed bug situation was caused by the building. They took my photographs, that was my evidence, and used it in conjunction with their evidence to turn my defense against me. Again, the exterminator, Mr. Brown, I don't know if I'm able to say that, but I've seen him on several times in the society, and unfortunately, he told me he was paid very dearly to offer his testimony. I don't know if I could bring that up or not, Your Honors, but I will say that, and I'll raise my hand to God that he told me he was paid by David D. Donnet to offer his testimony in court. The judge dismissed my counterclaims without a hearing, dismissed my deposited motions without a hearing, and furthermore, she dismissed my business records, my medical records, and also the government documents that were from HUD. Failed to introduce those into evidence.
Your Honor, I don't mean to interrupt, but he's now casting aspersions on me that are just blatantly false.
Mr. Donnet, this is oral argument and we'll take his comments for the purpose that they're offered. Thank you. And your objections noted. You can continue, Mr. Austin.
Yes, ma'am. And Your Honor, when I entered the courtroom as a pro se defendant, the first thing Magistrate Hathaway said to me was that I found to be biased. She said, "I see you're not a member of the bar." And that sort of struck me in my heart. And I was constantly objecting to her shilling a witness. Christine Valut submitted an internal document which stated that they knew that I was calling on my rent, and once they discovered that, they withdrew the claim. In 2025, they came back to court and lied under oath. During cross-examination, she denied being in abatement from 2022 to 2024. Then she later turned around and recanted her testimony. I objected to strike her credibility, and the judge said overruled. So that way, shilling a witness that committed in open court.
You have about 1 minute left, Mr. Austin.
And Mr. Donnet is fully aware they stipulated in court that he would. Okay, Judge Your Honors, my prayer for relief is that this systemic deprivation of rights, housing rights, that are it's an affront to the system, it's an affront to public housing, it's an affront to the taxpayers. Please do not let David Donnet continue this scheme that they've been perpetrating for years. I'm only one victim, but I speak for everyone. Housing is much important.
Thank you,
Again.
Mr. Austin. We appreciate your presentation this morning. Thank you both for your advocacy. We will take the matter under submission. We will issue a timely written decision in the case. And you may both log off now. I think our staff will help us in bringing in the attorneys for the next case.
Thank you, Your Honors.
Thank you.
Thank you.
All right, the next case is C250058, Paeonian Enterprises LLC versus Fitworks Holding LLC. I see that the attorneys have appeared on camera. If you would both please state your appearance, your name, the party you represent, and your readiness to proceed, just so we can do a microphone and camera check.
Certainly. John Christie on behalf of Fitworks, the defendant appellant.
Thank you, Mr. Christie.
And Ryan Hemmerly on behalf of Paeonian Enterprises, the appellee.
Thank you, Mr. Himmerly. All right, Mr. Christie, would you like to reserve time for rebuttal?
I would like to reserve 5 minutes. Thank you, Your Honor.
All right, I will give you a 1-minute oral warning when you are nearing the end of your initial presentation, and you may begin when you're ready.
I appreciate that, Judge. Thank you. May it please the court. This matter relates to a landlord-tenant matter that's a little more complicated than that. Otherwise, we probably wouldn't be in front of your honors. Fitworks was a tenant at a property owned and or controlled by Paonian. There is a change in, I don't think in ownership, in fact, but the name, the same principles transferred the original lease to Paonian. That is ultimately not an issue in the case. This is a de novo review of the summary judgment granted in a case with a somewhat interesting procedural history. Mr. Hammerly is the third counsel involved. He describes interim counsel, which I think is an unfair characterization of his predecessor, having seen her discovery request, and she had the opportunity to fully brief the initial summary judgment that was filed. Discovery did conclude. My summary judgment was filed, fully briefed, and ready to be argued. And then Mr. Hemmerly appeared. The court reopened discovery. The plaintiff filed its own summary judgment and additional briefs. Ultimately, the court denied my summary judgment, granted the plaintiff appellee's summary judgment. The standard here, well founded, is that there has to be no issue of material fact in order for either party to win a summary judgment. It has to be a one conclusion matter that any person is determining in this case. And when your honors have an opportunity, I'm sure you've already had the opportunity to review the opinion from the trial court level, there's words used that.
Let me cut to the chase
Sure.
here, Mr. Christie. So looking at Fitworks' summary judgment motion, the only evidence that you submitted in support of that motion was the Osborne affidavit, and it has a total of 3 sentences in it. So how does that affidavit result in the conclusion that Fitworks is entitled to summary judgment as a matter of law?
Well, Your Honor, and I believe it was pointed out in the plaintiff appellee's brief, that issue, I didn't appeal that issue because candidly, in reviewing both of the briefs and reviewing the
Well, isn't that one of your assignments of error? One of your assignments of error is that the trial court erred in not granting Fitworks' summary judgment motion.
Sure. Well, with respect,
Are you
to
abandoning that?
I ultimately, I don't think it's a critical point and a critical issue because as we've proceeded through the matter, as I look at things, the reality is we've got a contract drafted by the plaintiff appellee. And if the court determines
Is that even in the record?
it is.
And which contract are you talking about? The lease or the addendum?
The lease, well, the lease and the addendum, I believe, were attached to the complaint as a single document. The lease is obviously amended by the addendum. The addendum has approximately 12 points in it. And
you're
Your
claiming
Honor,
that both of those were drafted by Paonian?
correct.
And that's
Well,
in the record?
Paonian's predecessor and then Paonian. Even though at one point prior counsel indicated that they didn't draft it, current counsel indicated that they did draft it, which right there.
And what piece of evidence did counsel, the attorneys are testifying?
I'm sorry, I don't know that I understand your question.
Well, you're saying that it's established in the record that Paonian drafted these documents, and then you're attributing that to counsel. We need evidence. This is summary judgment, so we need evidence.
Understood, Your Honor. In the initial brief in opposition to my client's summary judgment, in the body of the pleading, counsel argued, and again, facts, I hear you, that they didn't draft it. There was no affidavit, there was no anything else. In the supplemental filing by current counsel, there was an affidavit where Paonian takes credit for having drafted it. So that's more of a sort of a footnote thing of the inconsistencies of the positions they're taking. Because yes, we've got an affidavit and that is evidence and that is before your honors. the statement of counsel, although, you know, it's a signed pleading, it's Rule 11, I don't think that carries the day one way or the other. We do have that addendum, which I think is the critical issue. I think even opposing counsel will agree with me that it's the critical issue in this case.
Did an
In that-
event happen under the addendum?
Say that again, I'm sorry?
Did an event happen under the addendum?
Yes, my client advised. So to give you a little bit of background, that as I was reviewing the briefs last night, my client acquired this site right before COVID. It was already distressed property. It's a gym. It's a workout facility.
I'm
It's a
not
fitness
sure
center.
that's responsive to my question. Did an event happen under the addendum?
Yes, because of what I was just mentioning, you had people weren't going to gyms. They weren't allowed to go to gyms. So FitWorks advised Paonian that they were going to exercise the addendum, which required the plaintiff to execute closing documents, assume debt because there were several locations at
Well,
the time.
okay, let me pause there. As I read the addendum, it defines an event in two ways. The first thing that constitutes an event is if FitWorks gives 90-day notice by a certain date that it wants to exercise the 1-year buyout. And if FitWorks is exercising that option for an event, it has to pay $10,000. The second
Correct.
thing that would constitute an event is if FitWorks decided to close the location short of the 2-year addendum period. Did either of those two things happen?
So I believe Your Honor is combining a couple paragraphs with your first version. An event was declared FitWorks indicated to Paonian that it was exercising its option to sell that site to Paonian. And at that point, if one looks at the document as a whole, one of the requirements is to complete closing documents relative to the debt that was being assumed by Paonian.
I'm not asking about whether Paonian breached. I'm asking if an event happened.
Yes,
And you believe the event happened because FitWorks gave the 90-day notice that it wanted to terminate and exercise the 1-year buyout.
exactly, Your Honor.
Okay. Was the $10,000 paid?
No, because the closing documents were never signed by Paonian.
All right. And is it in the record that the $10,000 was not paid?
I believe so. But I believe Mr. Hammerly would stipulate to that fact regardless.
Okay. And I have some questions about the way that the property was vacated.
Sure.
So it's my understanding, having reviewed the record, that there was the notice to vacate given by Paonian in November to leave the property, and that occurred after what they're going to characterize as a 2-month period of holdover where no rent was being paid after that 90-day notice was given. And that some number of days, I think 4 days later after the notice to vacate was given, that FitWorks left the property. Did it do that voluntarily of its own accord? Was that a decision that it made, or did it do that because it was forced to do it by Paonian?
It did it on its own accord when Paonian refused to execute the documents, and when Paonian was actively engaging FitWorks employees to remain there. I mean, they're basically, in my mind, stealing the business out from under us and made the determination that they didn't need to pay us. They could have everything they wanted without assuming the debt.
What provision, I mean, you keep answering my questions by pointing to conduct of Paonian.
Sure.
What provision in the addendum required Paonian to enter into an agreement?
I believe that it is, and I don't have it right in front of me, and I apologize. I believe it's paragraph 7 or 8 of the addendum.
Can you explain to me how that wording required Paonian to take action? Because, I mean, I believe it says something like, a more formalized transactional agreement will be completed at the time of an event.
I think, again, I don't have it right in front of me, but I think your reading is at least spirit dead on, if not an exact quote.
How does that impose an obligation on either party to enter into any specific agreement?
Because without those documents, to transfer anything back and forth, you can't do. You've got that addendum that's almost scratched on a napkin, 12 point, what has to happen. And one of those points very clearly says the parties will execute these documents. So as to, customer list, client list, as to, equipment, which my client had to separate from UCC filings.
What if your client, what if FitWorks was to put in this, let's say an event happens, FitWorks is going to close the gym. It's COVID. They're not making any money. They need to close the gym. They need to get out of this lease. And they tell Payoneer, we're leaving, we're exercising our buyout under this addendum. And, oh, by the way, Payoneer, you owe us $8 billion. And they demand that as a term of this transactional agreement. And then they claim, oh, Payoneer didn't enter into the transactional agreement, breach of the addendum. How would you respond to that?
Your Honor, a document that Payoneer drafted that says this is what's going to happen. And again, at best, it's vague, thus an issue of material fact, thus summary judgment's not appropriate. That's at best from Payoneer's standpoint. But they drafted a document saying this is what they were going to do. If they failed to do their due diligence, if they overlooked it, I don't know, that's their issue, and that's an issue for their people. But I would say that instead, what I would suggest to Your Honor is by allowing summary judgment to stand, you're saying, hey, party, if there's something in the contract that you decide after executing it you don't want to do, that you can back out of the contract in its entirety, which is what happened here. Hey,
I've asked a lot of questions and you're nearing the end of your time.
I know, I'm over my time.
Can I ask a
Sure
question?
my colleagues have time. Yeah, go ahead.
So I maybe I'm a little slow here. So your argument is that your client didn't breach because Payoneer didn't do these transactional documents that are required. Is that what you're arguing?
Essentially, I mean, I'll argue against myself briefly, and I'm aware of the time overage that I'm at. Certainly, Payoneer's failure to execute those documents is a breach by them. Now, clearly, my client did not pay the $10,000, which is a breach by my client. However, their failure to do the documents, sorry, I'm putting my hands in front of the camera, their failure to sign the documents goes, it's the same thing. So I don't think we breached because I think we owed the money after we signed the contracts. But again, I'm saying,
help me understand this contract, because
Sure.
the way I'm looking at it is the only way to trigger an event is the 90-day notice and the $10,000 payment. I thought that's what the event was. It included the 10,000. Is that not true?
I think there are a number of things that have to occur when an event is triggered. And I understand Your Honor's reading, and respectfully, I disagree that is here's $10,000 and here's the event. I think it's the event, and then the rest of the paragraphs need to be met.
So the event in the way you read the contract is the event only includes the 90 days?
That is how I read it. And again,
Okay.
to the whole point of my argument is how I read it, how Your Honors read it, how counsel reads it, and how the trial judge read it could be 6 different things, which goes to an issue of material fact, and therefore the trial judge's opinion and thinks and concludes is improper at the summary judgment phase.
Okay.
So whether my read is correct or Your Honor's read is correct, I don't think the court needs to make that determination, because I believe that's an issue for the finder of fact, because clearly, as I've gone way over time, there's confusion on that issue. Thus, summary judgment's not
If we
appropriate.
determine the contract's ambiguous, right?
Correct.
Otherwise, it would be a question for the court.
If the contract is not ambiguous, then I think the court then has to determine what order those paragraphs have to be completed,
Okay.
which again goes to an opinion and a finder of fact issue as opposed to a legal issue.
Okay. Thank you.
Thank you. And Judge Bach, because I'm way over, I know.
I'll actually ask the question. It's probably more appropriate for your opposing counsel.
Thank you very much. Your Honors, do you object to me sitting down and being off camera with my camera on, or should I remain? I have to stand. You can see my arms move, and I got the nervous energy.
You can manage your camera however you need, and we'll be back to you in just a moment.
Thank you, Your Honors.
Mr. Hemmerly, we've given your opponent about 5 extra minutes on his initial presentation, and I will afford you the same extra minutes. So you'll have 20 minutes rather than 15, given that we asked a number of questions in his presentation. And you may begin when you're ready.
All right. May it please the court. So I think this, at its core, this appeal does not present genuine issues of material fact. And at its core, I think it's really kind of a straightforward breach of a commercial lease and an addendum that followed. Fitworks at the beginning, when the addendum was signed, was having difficulty paying their rent, and it's acknowledged by Fitworks. And Paonian and Fitworks came together and attempted to create a rental structure because of COVID that would enable Fitworks to more easily cover the rent. And so they did that. They set forth the addendum, which provided, a sort of an escape clause if Fitworks was having difficulty.
And do you agree
question about that?
Yes, yes.
Sorry. So here, I have a couple of questions actually about that. So reading through this, an event occurred one of 2 ways. Either Fitworks exercised the option for the buyout with a $10,000 payment, or decides to close the White Oak location during the term of this lease for any reason. Correct?
Correct. Yep.
Okay. So with that in mind, then I'm going to skip forward a little bit. And it says both parties agree that upon the event, the LA Fitworks LLC will assume all liabilities of the Fitworks White Oak location, and Fitworks will be released from any future liabilities. I was reading the back and forth emails between the parties, and it seemed like the big sticking point was the back rent. Isn't the back rent one of the all liabilities?
The back rent certainly is one of all the liabilities. Yes, yes. And Paonian's position is quite simply that had the event occurred and Fitworks provided notice, so there's a condition precedent that Fitworks was not already in default at the time that they executed the addendum. And so in other words, when the event occurs, there's a condition precedent that Fitworks cannot be in default at that time.
Where does that say that in the addendum?
Well, that's our position, Your Honor, that's basic contract law, that a breach cannot occur if the one party's already breached. So when defendant breached by not paying rent leading up to the event, remember the event doesn't happen until much later, but Fitworks hadn't paid rent up until the point that they gave their notice. They didn't pay rent for the entire year. So
they're in breach of the lease at that point, right?
That's correct. Yeah, that's right.
And so doesn't this result in essentially a windfall to Paonian, because Paonian is attempting to collect not only the rent, which it would have been due all along, right? Like it's due the lease damages no matter what, when there's a default under the lease. But now it's claiming to be owed this extra $39.95 a month, going all the way back to October of 2019 for the equipment and the membership. And what was the consideration for that? Like, how did it become entitled to not only its lease damages, but also like the money for this business that it never actually owned? Shouldn't it be either or?
So it is, and Paonian is not seeking that. The amount that's set forth is only the contract rent. That's why this was a liquidated damages case. Paonian is not seeking anything beyond.
So you're
the rent.
claiming that the damages amount that was awarded below does not include the $39.95 per month?
The rental value, yes. It is the rent that they would have had to pay under the addendum. The addendum sets forth what the rent should have been. So that amount that was awarded is the rent for the entire year that FitWorks basically didn't pay rent. So they were in the.
But isn't the $39.95 a month, that's not rent. That is money for the equipment and membership, because there's an option there. FitWorks, if it leaves early, can either give the equipment and membership to the new entity controlled by Paonian, or it can take its equipment and membership and pay $39.95 a month to Paonian.
If it's not in default. But if it's in default.
Where does it say that?
Well, the lease controls overall. And so the addendum, again, there's a condition precedent that the addendum comes into effect if the lease is not in default, if FitWorks isn't in default. But FitWorks hadn't paid rent for the entire year leading up to this.
Help me understand that. I'm not following that argument because I don't see language that says that in the addendum. So I'm not understanding that logical leap. Walk me through that.
So the addendum provides for an amount of rent that will be paid if FitWorks fails to vacate the premises. It basically sets forth a new basis of rent. The rent under the lease agreement was significantly higher than it is under the addendum. So the addendum basically provides what the rent will be for going forward. Now, FitWorks could have continued paying its rent up until the event, at which point it had two options. One, to pay $10,000 and to take its equipment, or it could assign its equipment to Paonian.
So you're claiming that the rent got cheaper under the addendum?
It did. That was the
But
purpose.
that's not what this rent schedule reflects. I mean, I'm looking at it and it's showing like in October of 2019, they were paying $8,000 a month. And then in July of 2020, they were paying $8,500 a month. And then October of 2020, $9,000 a month, and it just keeps going up.
So the addendum provided a cheaper amount of rent overall. That was the purpose of the addendum. And then when the damages were assessed, it was assessed back to the contractual rate of rent.
So wait, were they in breach of the lease when they entered into the addendum?
The short answer is I don't know.
But I thought that they were not paying. I misunderstood you. I thought they were not paying rent prior to entering into the addendum, and that's the reason why you entered into the addendum.
So they had difficulty paying the rent. They weren't paying the rent on time. So there had been multiple breaches leading up to the addendum. But at the time the addendum was entered into, the addendum solved any breach. And as to the month that the addendum was entered into, I don't know at that time if they had not yet paid the monthly rent for that. But yes, there had been breaches leading up to that.
So at the time they entered into the addendum, you said the addendum solved any breach?
That's correct.
What does that mean exactly?
Essentially, if they were in default, if they had not paid that monthly rent, the addendum put them back on target. It was essentially a modification of the prior terms of the lease, and it enabled them to get caught up.
Then could you tell me your argument again about why you think the addendum doesn't apply because they were already in breach when they entered? I'm getting confused.
So the addendum,
they were already in breach because they hadn't paid rent.
That's correct.
So are you saying the on the one hand, you're saying the addendum tried to fix that. On the other hand, you're telling us that the addendum doesn't come into play because they had already breached, or?
No, I'm saying the addendum did fix that, and that was the intention
Okay.
of the addendum. And I think they made a couple payments under the addendum, but then breached the addendum and failed to pay for the year in which they vacated.
So the addendum gave them a clean slate on any lease breach. So all we're looking at here is the addendum.
That's correct.
And how did they breach the addendum?
They failed to pay rent under the addendum.
Under the addendum.
Yes. So for the months of January, that the year in which the addendum was entered into, January going forward, through the time that they vacated, they failed to pay rent.
What was rent under the addendum? How much?
I don't have that on offhand, Your Honor.
But it doesn't, does the addendum itself say what the rent is?
I believe it does.
Is that the rent schedule that's on the bottom of the addendum?
Yes, it is.
Okay.
And what happened with respect to the $39.95 a month payment? So the addendum by its plain terms contemplates that if there's an event, that FitWorks can do one of two things. It can either leave its equipment and members behind for Paeonian's new entity, or it can take its equipment and members, but it has to pay an extra $39.95 a month going back to 2019. The record's clear that FitWorks took its equipment and membership, but I don't view that as necessarily being a breach of the agreement, because the agreement or the addendum contemplates that they could do that. They just have to pay $39.95 a month going back to October 2019 for that benefit. Does the record establish that FitWorks failed to pay the $39.95 a month?
It does, Your Honor.
Where would I find that evidence?
Mr. Anevsky's affidavit. There's an affidavit of Lou Anevsky appended to our original motion for summary judgment.
And it clearly says that the $39.95 a month wasn't paid?
What it says is that no rent has been paid. So that would be inclusive. I don't know if it specifically says the amount, but it does say no rent has been paid.
But that's not considered rent though, the $39.95. I mean, how would you define that as rent?
I think nothing was paid. So not only was the $39.95 not paid, but nor was any rent tendered during that period of time either. Ultimately, FitWorks fell behind on payments, on any payments, fell behind on rent, fell behind on paying the addendum. And ultimately, Paeonian sued for breach of contract. And FitWorks basically filed counterclaims for Paeonian's breach of contract in not following through on the addendum. And at the end of the day, the trial court sided with Paeonian because the evidence demonstrated that FitWorks had breached the contract. And FitWorks has repeatedly, during the course of the appeal, brought up questions as to whether or not the addendum was ambiguous. But the trial court found that it was not ambiguous. And FitWorks' own motion for summary judgment acknowledged that the addendum was not ambiguous. And so that issue of ambiguity was not raised or preserved at the trial court for this appeal.
Are you suggesting that we, on our de novo review, are not allowed to determine that it's ambiguous?
No, not at all. But FitWorks acknowledged that it was not ambiguous in its motion for summary judgment. So it's changing its position now, but throughout the trial court, it asserted that the addendum was not ambiguous.
What about the argument that Paeonian was required to enter into a transactional agreement? The language in the addendum says a more formalized transactional agreement will be completed at the time of an event. What do you make of that Does that impose any obligation on either party to do any specific thing?
So I don't think it does. In its broadest sense, I think that might be considered an agreement to agree. But in its most narrowly tailored view, I think if there were a requirement on either party to initiate a negotiation at the term of the event, it's either obviated as to Paonian because of Fitworks breach, or it would be incumbent upon Fitworks to say, hey, I'm interested now in exercising my rights under this addendum because there's an event that's occurred. And Fitworks didn't do that. In fact, Fitworks maintained, and the record shows, that Fitworks maintained radio silence. And then when Paonian was finally able to make contact with Fitworks, Fitworks attempted to renegotiate the terms of the addendum as opposed to exercising one of the two options set forth therein. And so, so yes, I think, but for those two reasons, I think the addendum either provided nothing for the parties to do, or at minimum, it required Fitworks to come forward to exercise its options under the addendum. But I really, beyond that, I have nothing further, and I'll submit on our briefs.
Thank you.
Thank you.
All right, Mr. Christie, you have 5 minutes remaining. And your microphone is muted, so we cannot hear you.
Good thing I didn't make any brilliant points right there. Council suggests that we conceded something in our brief, and thus it's a fact that can't be disputed, although he cites extensive case law that says each summary judgment has to be determined on its own. So he can't use our summary judgment arguments against or our statements.
On that point, I want to make sure, going back to where we began, I want to make sure that I understand the nature of your arguments vis-a-vis the two summary judgment motions. So are you continuing to ask for our review as to Fitworks summary judgment motion, or are you abandoning that claim?
I believe, and I'm going to answer you backwards, and I apologize. I believe that it is clear that Paonian's summary judgment was improperly granted. I can see a path based on my arguments there that mine was properly denied as well. However, as long as we're here, we're here.
All right, thank you.
Now, counsel suggests that there's radio silence, but the record has the communications where we're reaching out trying to get those closing documents. The issue of back rent and default and everything else, the entire purpose of the addendum was that we weren't paying rent, that we couldn't pay rent. The addendum, as I forget which one of your honors pointed out, it's a fresh start. It's a new page.
Yeah, but what the argument was is that after the fresh start that your client breached again by not paying rent.
And I understand that argument, but I would remind your honors that counsel said, I don't know if rent was paid. I think, I believe, I'm not sure.
Well, wait, that was about the prior lease.
I believe it was about
what I understood him to say was after the addendum was entered into and the fresh start was given, that there again was non-payment of rent.
And the vagueness of the damage claim goes right to your question, because you, and perhaps I'm, being too much.
Well, is there evidence in the record that you all paid rent up until you gave notice?
There is not. And likewise,
Okay.
There's not evidence that we did not.
Okay.
As counsel said, I don't know, because we never got to that point. So how can you award damages? Because there is nothing in the record as to what and what amounts were paid in damages. And therein lies the issues. There are so many unanswered questions. We argue summary judgment with no mention of damages whatsoever. There's a ruling, and then there's a supplement that's rubber stamped saying, oh, his supplement says his damages are X. There's no cross-examination, there's no argument, there's no nothing, there's no evidence, there's just a submission saying this is what it is. So, and again, now I'm
Well, let
working
me ask you
backwards.
this question.
Sure.
If there were evidence that you all weren't paying, your client wasn't paying rent after entering into the addendum, then what?
Well, I would proffer that may well be the event, which is not very well defined. And I would also say,
How
you
is
know,
that the event?
well, what is the event based on that contract? I'm not sure.
Well, I mean, the addendum tells us what an event is. An event is one of two things. It's either the buyout with 90 days notice and paying $10,000, or it's FitWorks deciding to close the White Oak location during the term of this lease for any reason. So non-payment of rent is neither one of those two things. It might be separately a breach of another lease term, but it's not an event.
Well, so what I would suggest is that there is no requirement that rent is being paid for the addendum is executed without any requirements, and I get it, of lease being paid. And I know how silly that sounds because it's coming out of my mouth as I'm saying it. However, there is no question, I don't think anybody disputes that FitWorks said the event has occurred. Now let's go through the rest of the checklist in the addendum, and Paonian said, no, we can just take this stuff for free. I would also point out,
Well, I don't think that's what they're saying. I don't think they're saying they can take it for free. I think they're saying they take it subject to the terms of the addendum, which are specific. I mean, they're specific. They say that FitWorks can either take it, which didn't happen, or FitWorks can take it and pay $39.95 a month, backdated to October of 2019. And to be honest with you, I have scoured the record and I'm not sure if that happened. I'm not sure if FitWorks paid $39.95. Neither one of you are telling me anything to give me confidence that FitWorks did in fact pay $39.95, but I'd love to see something in the record that answers that question definitively.
And Your Honor, therein lies the threshold issue. But I would also point out, and I don't know if it was a misstatement or what have you, Paonian has and took the customer list. They know every single person who was going to that location. Now, the equipment was taken.
And you have about 1 minute if you'd like to wrap up.
Yep. So the statement that Paonian got nothing is false. They took the customer list. They took our local management. They operated this facility just as we did. There is so much ambiguity throughout that's why I don't believe that it's appropriate to say that there are no issues of fact. Your Honor just pointed out that you don't see anything. There's things that I'm not sure. There's things that counsel aren't sure. If the people involved aren't sure, how can the trial judge be sure that there's a one conclusion pursuant to Temple versus Wayne?
Mr. Christie,
Yes.
in the Paonian's motion for summary judgment, in the affidavit that was attached to that, it says that FitWorks provided notice to the landlord on April 6, 2020, that it would not be able to continue to conduct its business due to COVID-19, and it stopped providing rent. Did FitWorks continue its business beyond that point?
I honestly don't know, but I do know that subsequent to that, they attempted to get the documents for the transfer. And I believe there are numerous email communications relative to that.
Okay, thank you.
Thank you. Thank you, Your Honors, for the extra time and for your patience today. Stay warm.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Be well.
Very much.
Thank you, judges. Thanks, Ryan.
All right. Our staff will assist us in bringing in the attorneys for the next case, which is C-25-0064, Johnson versus Durrani.
Morning.
Good morning. Good morning, Mr. Williamson and Mr. Statman. For the purpose of ensuring that everyone's technology is working correctly, would you please state your name, the party you represent, and your readiness to proceed this morning?
Paul Williamson on behalf of Dr. Durrani and Cast, ready to proceed.
Thank you.
Alan Statman and Ben Moran, who's off to the side here on behalf of the appellee. Ready
Great.
to proceed.
Thank you very much. Mr. Williamson, you have 15 minutes this morning. Would you like to reserve time for rebuttal?
4 minutes, if you don't mind.
All right, and I'll give you a 1-minute oral warning when you are approaching the end of your initial presentation, and you may begin when you're ready.
I'll just tell you, most of my Zoom calls this week, some point in the middle of the conversation, I've been booted off my internet, so I have my phone next to me at the ready. But may it please the court, I want to take just a minute to set the table, and then I welcome the court's questions. I want to focus on 2 issues in the case this morning. First, the Dr. Saini, the appellee's expert radiologist, testified to the ultimate issue in this case, the surgical standard of care, which is one thing this court has consistently said is off limits for him. And you see that testimony then show up in the jury interrogatory and their negligence finding. Second issue I want to address is the adverse inference instruction. This court has already held that the adverse inference instruction given in this case is erroneous, though in some cases it is held that that was harmless error. I don't think the court can do that here because of the combination of trial counsel's commentary on Dr. Durrani's absence, which came in over Dr. Durrani's objection, and counsel's commentary on the instruction itself, particularly during closing argument, that I think in this case make that instruction more prejudicial than harmless. With that, I welcome the court's questions. I'm happy to start with either of those issues.
Thank you, Mr. Williamson. I do have a question. As to the absent defendant instruction, can you walk me through your prejudice analysis, given how highly splintered this verdict was? I mean, clearly the jury was able to rule in Dr. Durrani's favor, as it did so entirely in the Byers case, and did so on a lot of the claims in Ms. Johnson's case. So why was that instruction prejudicial, given that the jury was able to reach defense-friendly verdicts?
Yeah, I think that goes to show just how weak Ms. Johnson's case really was. You have a splintered 6-2 verdict, returning the verdict for only one claim. One thing I think I would caution against in that analysis, Your Honor, is that Dr. Durrani has come to this court before, bringing a prejudice argument, and where there's been a unanimous jury verdict finding for plaintiff on all claims. And the court has said, well, clearly the evidence in this case was so strong that the error didn't matter. And so we're going to affirm and deem the error harmless. I am now here on what is pretty close to the opposite end of the spectrum, right? Where you have a jury very narrowly finding for plaintiff on only one claim. If the court concludes that is also evidence that the jury was able to adjudicate the issues just fine and there's no harm, it's not clear to me where I will ever be able to sort of overcome a harmless error analysis.
I take your point. What should we be looking for? What would help us understand? The task of getting into the mind of a jury is difficult enough as it is. So what would we be looking for to help us understand when an instruction like this did in fact infect the jury's thinking?
I think you're looking for many of the factors this court outlined in, Hounshill, Stevenson, Green, kind of that era of cases. One major question is, was it a close case? And I think you clearly have that here, where you have a split jury verdict finding for plaintiff on only one claim. That tells you you've got a pretty weak case to begin with. And now the question is, what sorts of errors could tip the evidence or tip the case in plaintiff's favor? You have a jury finding here that among there are sort of two findings of negligence. One of them was that the risk evaluation sort of didn't justify the surgery. Well, the adverse inference instruction in this case comes as the first instruction in a block about weighing the evidence and, in particular, witness credibility. So if you go back and look at the transcript on the jury instructions, the procession of instruction is you've got to evaluate witness credibility. And then the very next instruction is Durrani is not here, and that gives rise to an inference that any testimony he would have presented would have been adverse to him. And then the court sort of goes into more evidence weighing or credibility weighing instructions. And I think that tells you sort of the purpose of the instruction is to tell the jury, like, you really shouldn't believe what Durrani was saying. And in this case, the principal question is, did the risk or was the possible benefit of the surgery sort of justified, or was the risk justified by the possible benefit of the surgery? And you have the court telling the jury, you shouldn't really believe what Dr. Durrani had to say on that important question.
And how exactly would that play out here? I mean, let's assume that Dr. Durrani, was in court trying to defend against this negligence claim. Presumably, he would say, I performed this surgery just fine. Like, I did a good job with this surgery. And didn't his expert witnesses say that for him?
His expert witnesses did say that for him. But you will notice, and this is why I think it's really important to look at the instruction combined with counsel's commentary. As Dr. Durrani's witnesses are testifying, you have counsel sort of hammering them with, yeah, but Durrani's not here, right? Durrani is in Pakistan, isn't he? Hey, jury, there are a couple of witnesses Durrani could have called, and they could have been here because they're not in Pakistan.
Isn't that, I'm going to interrupt you real quick. Reading your appeal, it appears that that's two separate issues for review. One was the improper instruction, and the other one was allowing Ms. Johnson to reference Dr. Durrani's absence and being in Pakistan during the trial and during the closing. Is that, it seems like you're combining the two here, though.
We are, Your Honor, because they are sort of separate errors in that I think the court needs to decide whether these two things were erroneous. But we are looking at what's the impact of the errors at trial on the ultimate outcome. And here I think you have sort of two mutually reinforcing errors. The trial was not split into, commentary on Durrani's absence and an adverse inference instruction. And so I don't think the court has to split them or should split them when it's thinking about, well, why was the jury instruction erroneous? The jury, and why was it prejudicial? It was prejudicial because of the things that happened at trial. Chief among them, plaintiff's counsel repeatedly hammering the very issue that's going to come up in the jury instruction.
Was that, was allowing Ms. Johnson to, as you put, hammer that, was that one of the bases for your motion for new trial or JNOV? Because I didn't see it in there.
Your Honor, though it's not something that has to be raised in the new trial or JNOV motion, because it was addressed in a pretrial motion in limine. The evidence will say once you have a decision on the merits, you don't have to continue to raise it in order to preserve it for appellate review. And so you have a pretrial motion in limine that gets overruled. But I'm going to interrupt you again. I mean, the assignment of error is, and I'm going to, is that actually, I don't have that directly in front of me, but basically that the trial court should have ordered a new trial. That was the assignment of error, correct? Johnny?
And it's my understanding, or I don't see any other way to read that as other than that the trial court erred by not granting the motion for new trial.
No, it's about the substantive relief we receive if the trial court goes our way on the evidentiary questions, which is, look, the trial court should have sustained our objection and should have prevented this commentary and this testimony from coming in. The trial court didn't do that. So then the question is, well, what's the remedy? If I came up here and simply said the trial court should have sustained the objection, I think the court would fairly ask, well, okay, what do you want us to do with that? Suppose we agree with you, Mr. Williamson. What do you want us to do with that? And the substantive relief we think the court should award here is a new trial, because based on the combination of evidentiary errors and a jury instruction that again, we know is erroneous and then makes the evidentiary problems worse.
So does that go to the Dr. Sayani issue as well? Because that was also not an issue raised in the new trial motion, right? It was a motion in limine.
Your Honor, I think the other thing I would point out here is we know the trial court is not going to grant a new trial motion on the basis of objections we raised before trial that get overruled. I think it's a little unfair to appellants to make them sort of go back to the trial court and say, hey, we objected, you overruled, but actually you need to do the whole trial over again because you were wrong.
But now
now
you have the doctor's full testimony that you can use to, like what you're doing here is to convince this judge that he was wrong in allowing him to so testify, and here's why, this is what he did. So it seems like that would be something that you would raise in a new trial motion.
Certainly something we could, though, Your Honor, I point out in
But
this
you're saying
case,
you don't have to, is what you're telling me.
you don't have to. We've got a definitive ruling on the record on the issue. And in this case, I point out, the trial court did not need all of Dr. Sayani's testimony to decide whether he could testify on the ultimate issue of surgical standard of care. And you have that both in a pretrial motion in limine and in a contemporaneous objection as Dr. Sayani is testifying about what he thinks Durrani did or didn't do well during surgery.
Well, wouldn't that be, as far as on appeal, shouldn't that have been its own assignment of error, that the trial court erred by permitting Dr. Sayani to testify to the ultimate issue, rather than the trial court should have granted a new trial, even though you didn't raise that to the trial court in that motion?
I am not entirely sure what to do if this is going to turn on the label of should you have asked the trial court for a new trial or should we order one here, given, again, issues squarely presented at the trial court, ruled on by the trial court, and for which I think the remedy is pretty clear if you, the court, agree with us.
And you have about 1 minute.
And I am interested in the merits of your argument on this. I mean, I know that we've been quibbling over the procedure, but I would like to hear a little bit more about your argument on Dr. Sayani.
So jury interrogatory, one of the findings of negligence is a misplaced screw. The only place that testimony comes in is from Dr. Sayani talking about during surgery, Dr. Durrani misplaced a screw. We think that's actually not the best read of the evidence, but that was his testimony. It's something that this court, I believe it was in Boggs decision, you have Sayani testifying about a misplaced screw, and this court pointing out an objection to that was properly sustained. The placement of a screw is an issue that's actually been covered in these cases before, and it's something Dr. Sayani should not be testifying to. He is the only one testifying to it. Bloomfield doesn't talk about it. And then you see it show up in the jury interrogatory on the negligence finding, which I think makes pretty clear you've got prejudice, you've got the jury relying on inadmissible expert testimony.
Can I ask a clarifying question here? It's my understanding, and I did read that portion of the transcript. It's my understanding that Dr. Sayani was looking at an image and said the screw is misplaced. I don't remember exactly what it was, but basically he looked at an image and said the screw is misplaced. But he also said that that Dr. Durrani misplacing that screw fell below the standard of care. Which are you arguing about here, or both? And if you're arguing about both, which is the more serious error?
Your Honor, it is both, and actually, it's also the part where it goes on to say, and it caused damage that
Yes,
caused further
that too.
injuries.
Okay, yes.
I don't think you can separate those out, because what he says is, this is what Dr. Durrani did. What he did breaches the standard of care, which is it's the standard of care for surgery, which he's not allowed to opine on, and you have damages as a result. Like, he is testifying to the ultimate issue on a negligence claim, and then of course, again, you see his testimony reflected back in the jury interrogatory. I don't think you separate those sort of three components. I think you just look at, you have in 3 paragraphs a physician testifying duty, breach, and damages, that duty, breach, causation, and damages that is not permitted under the evidence rules to testify to.
Thank you.
All right, thank you very much, Mr. Williamson. We'll be back to you in just a moment. And if you could please mute. Thank you. I see you did that. Thank you very much. Mr. Statman, we've given Mr. Williamson about 4 extra minutes, and so I will afford you the same length of time, and you may begin when you're ready.
Thank you, Alan Statman, on behalf of the appellee. I have to say, I've heard a lot of appellant arguments over the months and months that we continue to appear here. Everything I just heard is utter and complete nonsense based on the record. I'll start with the appellant complaining, well, I don't know what I have to do to overcome the harmless error rule. Well, guess what? He just might not ever be able to overcome it. He has no absolute right to overcome a rule. And if he loses because this court ruled it was harmless error. He talks about the fact that it was a split verdict makes the case weak. When the cases are not split verdicts, they argue, look, that's the prejudice of a group trial. Now, with a split verdict showing that the jury can differentiate between a case they believe deserves liability and a case that doesn't deserve liability, that's evidence of prejudice from a group trial. I don't know how you get it both ways. A plaintiff's verdict is valid if it is 6-2. A 6-2 finding isn't evidence of a weak case. It's evidence of a plaintiff prevailing on the claim the jury found. Additionally, if you read the interrogatory, which I'm sure you have, number 2, it says, we believe the misplaced screw in the nerve and the risk-benefit evaluation did not warrant surgery. This court has not ruled that Dr. Saini may not testify to misplaced screws. What happened in that case is different. As a matter of fact, you will see in this case and every other case that you have reviewed, the surgeon uses fluoroscopy during the surgery.
I'm going to interrupt you for just a second. Your opposing counsel is also arguing that the fact that Dr. Saini also testified to the ultimate issue, saying that Dr. Durrani's misplacing the screw and possibly other issues as well, fell below the standard of care and caused damages. Has there ever been a case where we said that that was permitted? In fact, I believe that there have been cases where we have specifically said that he couldn't testify about the ultimate issue.
Well, actually, he is perfectly qualified in this case to testify to the misplaced screw and the damage.
Misplaced screw, perhaps, but how could is he allowed to testify to whether that fell below the standard of care for a surgeon?
A 12-year-old could have figured this one out.
That's not what I'm asking.
She
I'm
wa-
asking if he was allowed as an expert to testify that a misplaced screw fell below the standard of care and caused the damages.
Absolutely. And let me go back to the fluoroscopy and explain why I'm talking about that. Surgeons rely on radiologists and neuroradiologists to look at the fluoroscopy is real time. They are taking x-rays of what they are doing during the surgery, and then those are read by radiologists. Additionally, following the surgery, they do x-rays to see if there are any issues with hardware placement. In this case, there was significant issues with hardware placement, and the plaintiff went on to lose a kidney from the hardware placement. That is all directly in a neuroradiologist's bailiwick to be able to testify as to what damage the misplaced screw was causing, because they are reading the radiology. Is that misplaced screw sticking in a nerve?
I want to make sure I understand, Mr. Statman. So is this, I'm not a doctor, so I'm not going to be able at the ready to use the correct medical terminology. I just want to speak as a layperson. Is this really about sort of like body alignment? Like this bone and that bone are supposed to touch in this way, and this screw and that screw are supposed to go in this direction to hold this bone and that bone together? Is that what this is about?
When screws are placed in hardware, they are supposed to go into specific parts of the bony structure. If they are put in sideways, crooked, or on the wrong trajectory, it can be harmless if the point of the screw ends up in a vacuous area of the body. The problem is where the screw touches, abuts, or pierces an organ or a nerve. Now, not all screws cause a fatality because they're in a nerve, but they're rubbing that nerve and causing pain.
And
This
I understand
particular case-
radiologists as being the kinds of physicians who take pictures of all that at a close level using specialized equipment, and that they understand how those pictures display the different parts of our anatomy and how those different screws and hardware would affect our anatomy. Is that what Dr. Saini was testifying to?
Yes, he's testifying to what is the causal connection from a neuroradiologist's point of view. And you will see the testimony is from a neuroradiologist's point of view. Is this screw properly placed? Is it not properly placed? And if it's not properly placed, what is the causative effect of it not being properly placed? He then sees on the imaging study as not just a radiologist, a fellow trained neuroradiologist. He sees where the screw is piercing a part of the anatomy, in this case a nerve, in this case a kidney. And the result of that is nerve pain, or in this case, a loss of a kidney. Dr. Saini does invasive procedures. It's part of the background that we elicit during the trial. He does procedures. They're not full-on orthopedic spine surgery, but he does all types of procedures and has where they're doing things, placing needles in the spine for epidurals, for steroid treatment, etc. So he is intimately familiar as a neuroradiologist with the nerves, connective tissue, and the bony substances. On top of that, he does invasive procedures in this area where he is sticking needles in between the bones, in between the vertebrae, and he has to avoid piercing through nerves and ligaments and causing damage. So a neuroradiologist is not just a reading radiologist out of his residency. This is someone that took years of additional training in neuroradiology.
Can I ask you a hypothetical? So let's imagine that a person had an unusual anatomical feature, a bone that was shaped radically differently from how that bone normally appears. And a surgeon was conducting some kind of surgery relative to that bone and needed to adjust how they typically do that type of surgery in order to accommodate for the person's unusually shaped bone and their unusual anatomical feature. And so they placed a screw and hardware inside that person's body differently than normally because of this person's, certain feature. Would Dr. Saini, given his radiological credentials, be able to opine as to whether the surgeon's decision to operate differently in that case was within the standard of care?
Yes, because what you may not know because you're not a doctor, and what I know, not because I'm a doctor, but because I've got 500 of these cases and I've tried 127, there are known anomalies related to the spine. So for instance, in the coccyx and the vertebrae that are above the coccyx, those can be fused from birth so that they don't have the movement they would normally have. That disrupts the count. So what somebody thinks is a fourth vertebrae in the lumbar spine may be a fifth. And that anomaly leads to treatment different. It leads to a different count and it leads to different treatment because that is an anatomical bone differential from what would be the wide range of normal. And
well,
so
is that within the surgical standard of care? When a surgeon treats something like that, is it the surgeon who's supposed to make the judgment call, or is that within the radiological standard of care such that the radiologist decides?
the surgeon working with the radiologist, it's a symbiotic relationship where when they have unusual situations, they pick up the phone and they talk to each other. That's not a habit of Dr. Durrani's. So when you see an anatomical alignment or bone malfunction that is different, some of those are readily diagnosed in the literature and have standards of care related to how they're treated. If you're talking about somebody that has a completely crushed L4 vertebrae from an accident 20 years ago, and it may affect where a screw goes, I don't know off the top of my head, because I haven't seen that, whether that requires a certain type of treatment. So those things could be an orthopedic call, but it's never an orthopedic's call to have the screw transcend the bone that it's going through. For example, you're going to put a screw into your door. Well, if the sharp end of the screw comes out the other side of the door, you've misplaced the screw, because you know for a fact you don't walk into people's homes that have pointy edges of the screws sticking out of the back side of the door where you and your children can get snagged on the screw. So these screws are supposed to go into the pedicle. They're not supposed to go outside the pedicle. They're to go into a bony substance, but not transcend the backside of the bony substance, where they can ultimately cause additional damage. And in this case, they did. But see, the jury's findings were twofold. They said the risks outweighed the benefits of doing the surgery at all. And then they also said that they believe the misplaced screw that went into the nerve was part of a risk-benefit calculation that should have been made, and it did not warrant a surgery given the risk of that type of screw placement. The only person that can tell whether the screw placement is proper and is causing a causal link to damage is the radiologist, because they come from the radiologic films. That's who's reading them. Now, Dr. Durrani also reads his own films. And if he disagrees with the radiologist, the standard of care is not to just go willy-nilly into the night doing what you want. It's to pick up the phone and document how those two come to a resolution of the issue. And that didn't happen and doesn't happen with Dr. Durrani. And the other interesting argument made, I just want to move on to something else quickly before I run out of time, is now we're getting a complaint that the jury instructions, how they are ordered, which ones come first, second, third, 10th, is prejudicial to Dr. Durrani. That's an objection I have never seen made.
I don't understand them to be making that argument. I think
Well,
they're just saying that the absent defendant instruction was prejudicial given its content and the closeness of the jury verdict here.
No, and he said the placement following the instruction on credibility. Okay, if it's not an issue, it's not an issue. But I did hear that very clearly in the argument. And when they talk about my comments about where Dr. Durrani is, that comes up for a number of reasons. First of all, every witness has an address, and that's the first question. State your name and address. So it comes up that way. It comes up from the fact that after 127 jury trials, we have been told that we are allowed to tell the jury that Dr. Durrani has chosen not to come, that he's beyond the subpoena power of the court, and that he will not be providing any testimony in the case. So I raise that with experts because they often say, this is what Dr. Durrani was thinking. And my response is, how would you know what he's thinking? He's not given any testimony in this case. He's not here. Perfectly legitimate. And what they do on closing that Mr. Williamson doesn't want to bring up is they talk about every doctor I don't bring in the courtroom. Well, Dr. Smith, just down there on Madison Road, and Mr. Stadman could have brought him here if he wanted to. Just like Dr. Durrani's not here, Dr. Smith's not here. And then I have to, in my rebuttal, explain they have the subpoena power to bring any doctor they want from Cincinnati here, and they've chosen not to do that. So
Well, I'm sorry. Excuse me. I think I'm a little confused by your argument. I mean, Dr. Durrani is different because he's a party. Dr. Smith is not. I'm not sure what you're arguing here.
That's their argument. They want to talk about all the doctors that are not here. Okay? They think somehow that helps them justify Dr. Durrani providing no testimony. So that spurs a response. They're right down the street. They can come in. Dr. Durrani's in Pakistan and doesn't want to appear. I can't help that. That's the facts. In voir dire, the only thing I say at this point is Dr. Durrani's in Pakistan. It's their clients over there. They'll have to explain or answer any questions you have about that.
Okay, but in the closing argument, it went beyond he's not here. It said when a party such as Dr. Durrani has relevant evidence or testimony within his or her control and the party failed to produce that relevant evidence or testimony, that failure gives rise to an inference that the testimony or evidence is unfavorable. So what that means is, excuse me, let me finish. What that means is you have an inference that Dr. Durrani's not here because if he had to take the stand, the evidence that would have been elicited from him would not have been favorable to his cause, to his side of the case.
Correct. And that's the instruction the judge allowed to be given. So of course I'm going to talk about it in closing argument. The judges, that instruction happens to be 98% correct. The problem with the instruction is the judge is supposed to give them the types of inferences that they can draw. There's this Ohio Supreme Court case on all fours related to that. And Judge Reese decided not to do it 100% the way the Supreme Court allowed it. So that's where the problem came up. But I see in various opinions and arguments that it's not recognized that the Supreme Court says that. But the curative factor is there is a further instruction on inferences. And that instruction tells them that they can draw an inference if they want and not draw one if they don't want. They clearly didn't want to draw any inferences in the Byer case because they found for Dr. Durrani,
And you have 1 minute left.
which is irrefutable evidence that they are looking at what is and is not admissible about the trial. They're not being prejudiced. If they were being prejudiced at Mr. Williamson's level, they would have decided Durrani's not here, he's not defending, bang, gavel, judgment for the plaintiff. They're not doing that. They would have decided all the claims in my favor and not just negligence. And to show you how well thought out the verdict is, they write out what they believe the negligence is. I don't know how a case can be more clearer that the arguments the defense has been making are absolutely wrong. And there was a recent concurring opinion by the chief judge in the first district where she said they need to show you that substantial justice was not done for Dr. Durrani. Substantial justice was not done. I don't know how Dr. Durrani didn't get substantial justice in this case where they two were tried. One person was found to not have a case and the other had a negligence case 6-2. If that's not substantial justice, and I challenge them to show you lack of substantial justice in this particular matter before you judges today. Can't be done.
Mr. Statman, you're out of time. Thank you.
And I'm finished. Thank you.
Thanks for your argument. Mr. Williamson, you have 4 minutes remaining.
All right, I think I'll start with the fact that almost nothing that you just heard appears in Appley's brief. So we had a long conversation about what happens in these cases generally or things that may have happened in this trial. None of that's in Appley's brief. And a long conversation about Dr. Sayani and what he testified to or didn't
Can you
testify to.
help me understand? I appreciate what you're saying, but I do want to get to the actual merits of Dr. Sayani's testimony. Can you help me appreciate the difference between a surgical standard of care that might go to like how a surgery is performed versus the placement of a screw and what a radiological image might reveal? And can we try to put this in sort of layman's terms?
I will do the best I can. So I think clearly inbounds for radiologist is, I'm reviewing the X-ray. This is what the spine is doing. Like, here's how much it's moving, how much it's flexing or not flexing. Like, those sorts of things I think are sort of clearly inbounds. Well, once you're in the spot of the surgeon is cutting so among the things that are clearly out of bounds, surgeon performed procedure X and you should have done Y. So you have that in some past cases, the court has said that would be out of bounds. And then I think the where we sit here is something like the surgeon has now cut someone open. And you have a radiologist saying, you should have cut here and not there. You should have placed a screw here and not there. When he's commenting on the performance of the surgery and whether you perform the surgery well or not.
Could
that I think is going to be a
Sayani
radiologist.
testify that the screw was placed in this position and it touched this nerve, or it was in close proximity to this organ and had this deleterious effect? Is that something a radiologist could opine on? I mean, I feel like radiologists do that all the time. They look at MRIs and they say, this thing is out of whack and this is causing this problem for this person.
So I wouldn't be shocked to see a radiologist say, yeah, look, you have these two structures that are close to each other. I'll point out, and this is one of the reasons we hammer what needs to be in Appley's brief. You don't get that in Dr. Siney's testimony. This conversation about the pedicle screw was going all the way through the bone. I'd point you to it's the transcript volume from July 18th, pages 115 and 116, where you see the testimony about the misplaced screw and our objection to it. What you have is Siney saying, look at these dots. This is where the cage is. They are misplaced. That's it. And then you have the question, and did that misplacement cause further problems? Yes, it did. Almost none of the detail that you heard from Mr. Statman a few moments ago shows up in that part of the transcript. You just have the screw's misplaced and it caused further problems.
But that's he's not, I understand your issue with it, but he's not really commenting on the surgery itself, right? In what you're pointing to.
He is. I mean, he's there talking about the interoperative radiological notes, and you have.
But wait, can't he talk about the screw looking like it's misplaced as a radiologist?
He could talk about where the screw is. I think once you're talking about the screw is misplaced, you have performed the surgery poorly or performed it negligently. We are now into the domain of surgeons. And I think it's worth pointing out.
Does he say that though? Does he, I'm just trying to get exactly what you are objecting to. Does he say that the surgery was performed negligently?
What he says is that the screw is misplaced, and then he's asked, does that fall below the standard of care? Yes. Did that misplaced screw cause further problems? Yes, it did. And among others, some of his sort of side commentary in that section is, you ought to know where you're placing things. And so you really do not get a lot of detail out of Dr. Siney.
Could he have testified that the screw looks like it was, in my view, in looking at these films, it looks like the screw was misplaced? Would that have been appropriate?
We think no. That sort of there's a pretty firm line once you're commenting on the surgeon's performance of the surgery, and particularly that question, did his performance fall below the standard of care?
But going to Mr. Statman's comment about putting a screw in a door and it comes out the other side. I mean, I think anybody can look and see, like, it looks to me like the screw was misplaced. I mean, how is that a problem for a radiologist to say?
Well, look, yes, a person can like look at a screw going all the way through the wall of a door and say that looks off to me.
They could look at a screw going through a bone and coming out the other side and maybe hitting a nerve or whatever, and do the same, right?
I mean, just that question itself is something I think we would all agree. You're going to need expert testimony to explain to a jury, like, here's what's happening and here's what that would do. Because there are certainly instances where you might see something in a surgery or in a radiological film that looks weird to you and me, that a physician would say, no, that's exactly what it's supposed to do. There are lots of anatomical features where you might look at it.
Isn't that something a radiologist has to testify to? I mean, the surgeon is going to just close the person back up. It's through radiological images and the explanation of a radiologist that we're going to know how the placement of the object, the screw, the plate, whatever it is, inside the person is touching or affecting other parts of their body.
I'm not sure the radiologist would necessarily get you that far.
Who else would explain that? I mean, my understanding of how this works is that if somebody has an injury, an incident, a problem that they're experiencing inside their body, that they go get some images taken by a radiological technician, and then the radiologist looks at it and says, this is the problem, I see this thing going wrong, and the radiologist explains what the issue is, not a surgeon.
You're still going to refer to other specialists for, like, how are we going to go about addressing this? You wouldn't have the radiologist or, like, sort of by himself ordering surgery to resolve whatever problem the radiologist identifies in the imaging. And again, Your Honor, this is not like an unknown issue. We have talked about Dr. Saini commenting on the placement of, specifically Dr. Saini, specifically in the context of Durrani litigation, commenting specifically on the placement of screws,
Well,
and that he's getting into ultimate issue.
I mean, to me, there's a difference between saying, okay, I am looking at this image and I've looked at thousands of these images before, and this problem looks like it's this part of this image looks like it is a problem, versus I'm seeing this looks like it's a problem. The doctor that did this was negligent, and that negligence caused damages. To me, there's a big difference between that. So I am asking you specifically for the areas in which Dr. Sayani testified that the Dr. Durrani surgery was below the standard of care and caused damages. Was there any other expert testimony other than Dr. Sayani that basically that was cumulative of that specific testimony?
No, Your Honor. It is just Dr. Sayani on misplaced screw caused damage, certain screws misplaced, screw placement was below the standard of care, the misplaced screw caused damages. That is only Dr. Sayani.
Okay, and then, I'm sorry. Go ahead, Judge Kinsley.
I just wanted to alert Mr. Williamson as to time because he's gone way over, but can continue to ask your question.
Okay, so my other question is, if hypothetically, if we were to determine that that was error, being that the jury also found that the benefits did not outweigh the risks for the surgery, and I can't remember the third basis, is there any harm here?
Absolutely, Your Honor. I mean, you have inadmissible testimony that clearly shows up in the jury's negligence finding. And now we are really slicing things finely if we're going to say, all right, you take out half of the jury's negligence finding, you take out the only evidence that supports it, and we think the outcome is exactly the same. I have been in front of this court and I have been asked, okay, you're telling me this evidence was admitted erroneously, but show me where in the jury interrogatory the jury relied on that. I have it for you here. I'm not sure what else to do if the court concludes that is also not good enough.
And Mr. Williamson, you've far exceeded your time. Thank you. Thank you very much for your presentation.
Absolutely, Your Honors. Thank you.
We appreciate both of your arguments this morning. We'll take the matter under submission and issue a timely decision. Be safe, be warm. That concludes our docket for the morning.